Obligations with subtopic nature and effect of obligations, and this is already part 3. We're done discussing obligation to give, and that is your real obligation, and obligation to do or not to do, and this is your personal obligation. In this video, what we're going to discuss is your breaches of obligations. For breaches of obligations, it may be classified into voluntary and involuntary. So when can you say that the breach is voluntary? If the debtor, take note that the debtor is guilty of fraud, default, negligence, or contravention of the tenor, then that is considered a voluntary breach. How about an involuntary? That is your famous fortuitous event. Why is there a need to note the difference between the two? Because if it is an involuntary breach, the debtor is not liable for damages. But please take note that this rule is not absolute. Subject yan to certain exceptions. What is your basis? Your basis is Article 1174. Article 1174 says that no person shall be responsible for those events which could not be foreseen or which though foreseen were inevitable, except, so that is your exception. Number 1 is expressly specified by the law, otherwise declared by stipulation, or the nature of the obligation requires the assumption of risk. How about if it is voluntary? The debtor is liable for damages. Basis is Article 1170. Those who, in the performance of their obligations, are guilty of fraud, negligence, delay, or they contravene the tenor, they are liable for damages. So we'll go to the first kind of voluntary breach of an obligation, and that is default or mora. So what is default or mora? That is the idea of delay in the performance of the obligation. So take note of the word delay. It is the non-fulfillment of an obligation with respect to time. So there are 3 kinds of default or mora, and that is number 1, your mora solvendi. Your mora solvendi, it is the delay of the obligor or the debtor to perform his obligation. So if it is a mora solvendi, the person involved is the debtor. The second kind is your mora accepiende. What is mora accepiende? That is the delay of the creditor to accept the delivery of the thing. And if we talk about mora accepiende, the person involved is your creditor. And the last is your compensatio morae. That is the delay of the parties or the obligors in reciprocal obligations. 2012 bar exam question MCQ, a debtor is liable for damages in case of delay if he is guilty of any of the following, except letter A is default, B mistake, C is negligence, and D is breach through contravention of the tenor thereof. So recall Article 1170, ano ang hindi kasali? That is letter B, mistake. Another MCQ, 2012, this term refers to a delay on the part of both the debtor and creditor in reciprocal obligations. Choices are mora accepiende, mora solvendi, solutio indebiti, and compensatio morae. So what is your answer? Yes, it's letter C. What did we say? If it is a mora accepiende, the person involved is your creditor. How about if it is a mora solvendi? Here, the person involved is your debtor. Mnemonics is SD card. So, solvendi is for your debtor. And if it is a solutio indebiti, recall that it is a quasi-contract. And our mnemonic there is SM. S is for your solutio and M is for your mistake. Because in solutio indebiti, there is a payment by mistake. Another MCQ 2012, the following are the requisites of mora solvendi, except letter A is the obligation pertains to the debtor and is determinate, due, demandable, and liquidated. B, obligation was performed on its maturity date. There is a judicial or extrajudicial demand by the creditor, and last is there is a failure of the debtor to comply with such demand. Answer here is letter B, obligation was performed on its maturity date. Why? Because in a cases decided by the Supreme Court said that there are three requisites which should be present in order for the debtor to be considered in default. And number one is that the obligation is demandable and already liquidated. Second is the debtor delays performance. And third is the creditor requires the performance judicially or extrajudicially. Question, when is there a delay? Answer, it depends. Because if the prestation is to give or to do, the debtor incurs in delay from the time the creditor demands from the debtor the fulfillment of the obligation. Take note that the demand here is either a judicial demand or extrajudicial demand. Basis is Article 1169. Those obliged to deliver or to do something incur in delay from the time the creditor judicially or extrajudicially demands from them the fulfillment of their obligation. What if the prestation is not to do? Here, the debtor cannot possibly incur in delay in negative obligations. Obvious naman yan kasi nga sa obligations not to do, wala ngang pinapagawa si creditor kay debtor. How about if it is a reciprocal obligation? What is a reciprocal obligation? We will be discussing that in detail when we go to the remedies. But for now, an example of your reciprocal obligation is a contract of sale of car. What is the obligation of the vendor or the seller? The seller has the obligation to deliver the car to the buyer. The buyer or the vendee, on the other hand, is obliged to pay the price of the car to the seller. So here, one party incurs in delay from the moment the other party fulfills his obligation. Basis is Article 1169. In reciprocal obligations, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfills his obligation, that is only delay by the other begins. In obligation to give and obligation to do, si creditor ba palaging magdi-demand kay debtor? Answer, no, because demand is not necessary when the obligation or the law expressly so declare. Example, your payment of taxes. Di ba si government naman hindi naman nagdi-demand sa inyo palagi. Number 2 is time is of the essence. Alam nyo na to, palagi itong dinidiscuss ng mga professors. Example is the famous wedding dress. And number 3 is when demand would be useless as when the obligor has rendered it beyond his power to perform. The second kind of voluntary breach of an obligation is your fraud or dulo. So what is fraud or dulo? That is the conscious and intentional proposition to evade the normal fulfillment of an obligation. Take note of the word intentional. So for your fraud or dulo, it may be classified into two, the criminal fraud and the civil fraud. For civil fraud, it may be classified into fraud in the performance of an obligation or fraud in the perfection of a contract. For fraud in the perfection of a contract, although ang discussion nito dapat sa contracts na, pero unahan na natin, there can be two, that is your dolo causante. Ano ang dolo causante? The deceptions or misrepresentation of a serious character employed by one party and without which the other party would not have entered into the contract. Basis is Article 1338. There is fraud when through the insidious words or machinations of one of the contracting parties, the other is induced to enter into a contract which without them he would not have agreed to. Another kind of fraud in the perfection of the contract is your dolo incidente. That is the deceptions or misrepresentation which are not serious in character and without which the other party would still have entered into the contract. What is your basis? That is Article 1344. In order that fraud may make a contract voidable, it should be serious and should not have been employed by both contracting parties. Incidental fraud only obliges the person employing it to pay damages. To distinguish these two, please take note of the applicable articles, because if it is a fraud in the performance of an obligation, the applicable articles is Article 1170 and 1171. But if it is a fraud in the perfection of the contract, the applicable article is Articles 1338 to 1344. Para mas lalo pang maintindihan, please take note of the purpose. Why is the fraud employed? What is the purpose? The purpose is to evade the fulfillment of an obligation. Whereas here, the purpose is to secure the consent of the other party so that he will enter into the contract. If the purpose of the fraud is if the purpose of the fraud employed is to evade the fulfillment of an obligation, ano ang sinasabi ni Article 1170? That is a voluntary breach of the obligation. And in case there is a voluntary breach of the obligation, the debtor is liable for damages. This is the reason why the creditor, or it gives rise to a right of the creditor to recover damages from the debtor. How about if the fraud was employed for the purpose of securing the consent of the other party so that he will enter into the contract? What would be the result? The result would be the cessation of his consent. And in that case, ano ang remedy ni innocent party? Well, it depends. Because if it is a causal fraud, then the innocent party can ask for annulment of the contract. If it is an incidental fraud, however, iba ang remedy ni innocent party. He can only ask for damages. Please take note also that if we talk about fraud in the performance of an obligation, it is present only during the performance of a pre-existing obligation. Whereas if it is a fraud in the perfection of the contract, ang fraud present siya only at the time of the birth of the obligation. Question: can a person waive fraud? Answer: it depends. Because if the waiver is for future fraud, that is contrary to law and public policy. Basis is Article 1171. Any waiver of an action for future fraud is void. How about if it is a past fraud? Then that is considered valid because that can be deemed an act of generosity. Ang renounce mo talaga dyan is the effect of fraud, more particularly the right of the party to indemnity. Bar question 2012. It is an intentional evasion of the faithful performance of the obligation. Choices are negligence, fraud, delay, mistake. Ano ang sinabi ko? Take note of the word intentional. So your answer is B, that is fraud. The third kind of voluntary breach is your negligence or culpa. The applicable article is Article 1173. So your negligence is that omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances not only of the persons but also of time and the place. So there are two kinds of negligence, and the first is your criminal. The applicable article is your Article 365 of the RPC. Another kind is your civil, and that can be classified further into two, and that is your culpa contractual and culpa aquiliana. For civil negligence, we said that it could either be a culpa contractual or culpa aquiliana. So let's take a look at the difference between the two by starting about the relationship of the parties. Take note that in culpa contractual, from the word itself, contract. So in culpa contractual, there is always a pre-existing contractual relationship. And the source of the obligation in culpa contractual is the breach of the contract or the non-fulfillment of the contract. In culpa aquiliana, there may or may not be a pre-existing contractual relation. This is the reason why your source of the obligation there is the defendant's negligent act or omission itself. How about if you want to prove your recovery in culpa contractual? What is the requirement of the law? The law says that you present only the proof of the existence of the contract as well as the proof of its breached or non-fulfillment. That is already a sufficient prima facie to warrant a recovery. But if it is a culpa aquiliana, the law says differently. Anong sinasabi ng batas? The negligence of the defendant must be proved. Next, the proof of diligence in the selection and supervision of employees is not available as a defense in culpa contractual. Whereas if it is culpa aquiliana, it is available as a defense. Last is the character of the negligence of the defendant. In culpa aquiliana, it is substantive and independent, whereas in culpa contractual, it is merely an incident in the performance of an obligation. Para mas lalong maintindihan, let's take a look at this 1977 bar exam question. Taxi driver D was driving recklessly, so he killed pedestrian P and his passenger Y. Discuss the source of the obligation of the driver and his employer to both the passenger and pedestrian and the defense available to the employer. So here, ang pag-uusapan lang muna natin is culpa contractual. Let's focus on culpa contractual. So what is the source of the liability if it is a culpa contractual? That is your breach of the contract of carriage with passenger. That is the source of the liability. Reason, because if you are a common carrier, you are obliged by law to bring your passenger safely to his destination. Basis is Article 1755. So in culpa contractual, who is liable? The liability is only to the employer, and the employer's liability is direct and primary. This is the reason why the heirs of the passenger, take note ha, passenger lang, kasi si passenger lang ang may kontrata. Pedestrian, walang kontrata. So the heirs of the passenger may proceed against the employer only under the civil code. And since the liability of the employer is direct and primary, therefore, the employer cannot relieve himself of liability by proving due diligence of a good father of a family. Basis is Article 1759. Same bar problem, but this time we will be talking about culpa criminal. Tapos na tayo sa culpa contractual. So, culpa criminal, what is the source of the liability? The source of the liability of both the driver and his employer is the crime committed by the driver. This is your culpa criminal. So, the liability here of the driver is direct and primary kasi siya naman yung pumatay, siya naman ang nakasagasa. How about your employer? His liability is subsidiary. Basis is Article 103 of the Revised Penal Code. But take note of the requisites. For the employer to be subsidiarily liable, he must be indeed the employer of the convicted employee. Second, he is engaged in some kind of industry and the crime was committed by the employee in the discharge of his duty, and ito importante, the execution against the employee has not been satisfied due to the insolvency. In culpa criminal, the heirs of both the passenger and the pedestrian may proceed against the driver and his employer under the revised penal code. But take note that in culpa criminal, the employer of the driver cannot relieve himself of liability by proving due diligence of a good father of a family because of the very nature of his obligation. Same bar problem, pero ang pag-uusap pag-uusapan na natin ngayon is your culpa aquiliana or your quasi-delic. So what is the source of the liability? Liability nino, ni driver and his employer. The source of the liability is the quasi-delic committed by the driver. That is your culpa aquiliana. And the heirs of the pedestrian lang ha, hindi kasama si passenger. Take note, the heirs of the pedestrian may proceed against both the driver and his employer or against the employer only under the civil code. This is because the liability of the driver is direct and primary. Basis is Article 2176. How about the liability of the employer? It is also direct and primary. Basis is 2180. Employers shall also be liable for the damages caused by their employees. But ano ang catch? In Article 2180, the employer of the driver can relieve himself of liability by proving due diligence of a good father of a family in the selection and supervision of his drivers. So in sum, this is the source of the obligation of the driver and his employer to both the pedestrian and passenger, and also the defenses available to the employer. Thank you very much for watching and have a good day.